Hi, this is Hennepin County Attorney Mary Moriarty. Welcome to our podcast, We Don't Have to Choose. We call it We Don't Have to Choose because we don't have to choose between public safety and equity and justice and changes and reforms that are based on evidence. Today, we're going to talk about the case of Marvin Haynes, and we're going to talk about how he was exonerated, but we're also going to talk about the measures that the county attorney's office took to make sure that an eyewitness identification or a wrongful identification never happened again. So first, we're going to have Andrew Marquardt join us to talk about that case. Hi, I'm here with Andrew Marquardt, who is the head of our Conviction Integrity Unit, or our CIU. But before he came to us, he had a significant role in the case of Marvin Haynes. Hi, Andrew.
Hey, Mary. Thanks for having me.
Of course. Can you talk about Marvin's case a little bit?
Sure. So Marvin Haynes was wrongfully convicted of murder and exonerated nearly 20 years later. So it's a 2004 case. It was a flower shop killing. And he was a teenager at the time. He was only 16 and was identified kind of early on as a suspect, and was brought in and eventually charged based on some really problematic evidence, which is going to be relevant to what we're here to talk about.
So let me jump in. You are now the head of our Conviction Integrity Unit. At the time, you were not. And so that case did not go through our Conviction Integrity Unit. It didn't exist then. But what was the legal posture? How did Marvin end up in court?
Yeah, so so I previously worked at the Great North Innocence Project here in Minneapolis, and we represented him, brought a post-conviction claim on his behalf. We had some new evidence that we had developed, as well as some pre-existing problems with the cases that we focused on as well. And one of the problems with doing post-conviction litigation of this type is we have very strict time limits in Minnesota. Usually you only get 2 years, and this obviously was way past that. So, fortunately, this office agreed to waive those time bars and allowed us to have our day in court and to be able to come in and put on evidence that we thought showed that he was wrongfully convicted. Ultimately, we were able to make that case, and this office agreed that the evidence was compelling and that he needed to be exonerated. So that was in December of 2024, and he's been out since then and is doing really well.
So from the office's perspective, we were monitoring this case, and we did waive the bar because in this particular case, we thought it was really important to hear what the new evidence was. And we didn't want any barrier, and we wanted to allow him to have his day in court. And the hearing itself took place over a couple of days. Is that right?
That's right.
So we were able to see what evidence was presented and ultimately agreed and joined in a motion to vacate his conviction and then dismissed his case. So can you talk a little bit about, you mentioned a little bit that eyewitness identification was a major issue here. Can you talk a little bit about how it played a role in his case?
Sure. So in his case, it was there were a few different pieces of key evidence, but really at the center of the case was these eyewitness identifications. And we know that eyewitness testimony is sort of notoriously flawed and just fraught with potential for error for all kinds of reasons, several of which came up in this case.
I do want to jump in there because we do know that, and we have, researchers have known this for a very long time. But I think in terms of the general public and perhaps prosecutors, it is some of the most compelling evidence when the victim of a crime or a witness to the crime gets on the stand and says, that's the person who committed the crime. and their certainty is equated to their accuracy. And so I don't think it was really in the public conscious that there were problems with eyewitness identification. And I just say that because I've been practicing, like I was at some time, like 24 years in court. And I remember at some point there were all of these staged things on Oprah and stuff like that, where the audience would just be participating and then suddenly someone would run in and do something dramatic and run out. And then they would ask the audience members to identify the person, and they were all wrong. So I think it took a while for that actually to get into the public. And perhaps at the time of this case, the public wasn't necessarily as familiar with that. And there certainly wasn't an expert witness to describe the problems with eyewitness identification in Marvin's case.
Yeah, I think that's fair. I think, we've learned a lot more since then. And I do think some of these things have sort of started to seep into the public consciousness a little more, maybe for some of the Oprah episodes you were talking about and things like that in popular culture. But we're learning more all the time. And a lot of the science on this is not super intuitive. And some of these things are things where it does help to have an expert explain to lay jurors who, they might not know. They might know, okay, eyewitness memory is not like a video recorder, like it's flawed. Okay, like, yeah, most people know that. But, they might not know the degree to which like extreme stress, for example, can inhibit encoding of visual memories, or the degree to which the presence of a weapon can distract from encoding visual memory of the face, or, the degree to which even really simple disguises, like a baseball cap, which we don't even think of as a disguise, can really severely diminish the reliability of eyewitness identification. So there's a lot of these issues that we now have a lot of really high quality social science research on. And, we in this office now have tried to make our prosecutors more familiar with those issues, but also, recognizing the role for experts to be part of these proceedings is important too, so that the lay jurors can really understand why these things matter.
Mm-hmm. I was struck by a book I read a long time ago called Picking Cotton.
Sure.
And it was co-authored by Jennifer Thompson and Ronald Cotton. Jennifer Thompson was the victim of a horrific sexual assault, and she picked out Ronald Cotton as the perpetrator. And as it turned out, it's a pretty fascinating story in that Ronald Cotton had been hearing rumors in prison that another man was responsible, that a particular person was responsible, and had manufactured a circumstance where he could have his picture taken with this other person. And in any event, like 10, 12 years after he had been in prison, DNA showed that other guy actually was the perpetrator. And what really struck me is, Jennifer Thompson she in good faith believed that Ronald Cotton did this. And I think lay jurors would tend to think, oh, if I were the victim of some horrific thing, that face would be just seared into my memory. And she talks a lot about the things that led her to progress from I think it might be him, to finally, when she got in trial, that's actually the guy. And it took a while for her to be able to process the idea that she got it wrong, because she felt horrific. She just felt horrible about what she had deprived Ronald Cotton of, which to me is also an indication of, obviously, if we get it wrong, we have put a victim or a witness through a terrible situation where they then realize that what they thought wasn't true, and they helped convict somebody who is innocent. And also the person who actually did it is still out there and could harm.
Bad for everyone.
It is bad for everyone. One of the things that I thought was really compelling about her story too was that, and this goes to police and the people, and this is behind a lot of the research about why certain things are recommended, that she was looking to the police officer for assurance. And so when she identified Ronald Cotton at one point, she said, "How did I do?" And the completely well-meaning officer said, "You did great." And she interpreted that as he knew who the person was, and he was saying to her she got it right. as opposed to he was just trying to be a nice person and assure her. And that made her more confident. So it's a really compelling book. I'm wondering if you can talk a little bit about some of the best practices now, or that we've actually known for a while. But what are some of the best practices to avoid that?
Yeah. So there's only so much we can do. There's always going to be sort of residual kind of risk of error, right? But there's a lot that police can do to minimize the risk of error. So in Minnesota, some of these have been put into a statute, what we call kind of the core four protections. So those are one, double blind administration, which means the person who's administering the lineup doesn't know who the suspect is or where the suspect is.
So
in the
potentially
lineup.
that law enforcement officer.
Yeah. So usually best practice would be like have an officer who knows nothing about the case. Do it. So you can't have these kind of subtle or maybe not so subtle hints that can suggest to the suspect to the witness who the suspect is. And you can avoid like the example you were talking about from the Ronald Cotton case, where there's this kind of feedback which artificially inflates confidence that then shows up in the trial. So double blind administration, super important. By the way, was not done in a few of the identifications in the Marvin Haynes case. It was one of the issues that showed up. You want to have good instructions to the witness, and specifically telling them that the suspect may or may not be in the lineup. So they should feel comfortable saying none of the above, or I don't know. They don't have to pick someone. That's really important, that they don't feel like, oh, this is a multiple choice test and like I have to fill in one of the bubbles.
Which goes to what Jennifer Thompson talked about, the idea that if the police are going to the effort of having you come down to try to pick out somebody, they must have the person. And so somebody who's making that identification or that attempt is already thinking that the person who did this is in that lineup or whatever it is they're looking at.
Yeah. The third issue is good fillers. So in a lineup, best practice is you have at least 6 people. One of them is a suspect, and 5 are what we call fillers, who are just non-suspects. You should never have more than one suspect in a lineup, because just sort of mathematically increases the odds of a lucky hit. But you want the fillers to match the basic physical descriptors of the suspect. So, because what you don't want in a lineup is for the person to be able to look at it and be like, oh yeah, only one of these people or 2 of these people are even in the right ballpark.
Has a beard, which I described.
Yeah, so things like race, complexion, age, hair, like the kind of like general features. Obviously, you're not going to have like 6 identical people, and that would sort of defeat the purpose of the exercise anyway. But you want it to be a real test of their memory.
And that was an issue in Marvin's case, as I recall.
Yeah, I mean, there was at least one instance where there was multiple suspects in a lineup. There were some low quality fillers who could be easily. I mean, the other thing you don't want is just like someone who can be really easily excluded, because then again, it's like you reduce the size of the lineup effectively. So that was an issue there too. And then the last thing is you want a confidence statement from the witness at the time of the identification. And this goes to some of the issues that I think you were talking about too, with in the Cotton case. So a witness's sort of subjective statement of their confidence should be taken with a huge grain of salt. Many people significantly overstate their subjective confidence level. But even so, to the extent it has value, it really only has value at that moment the identification is done, because after that, you typically have confidence inflation between the time of the identification and trial. Just basic psychology, like the witnesses at that point sort of adopted a story, and they tend to sort of attach to that story. They may do prep sessions between then and testifying at trial, all that kind of reinforce the story that they've adopted. So by the time you get to trial, they might have been 70% confident at the ID. At trial, 100% confidence. Never forget that face. And the thing is, they mean it. They're not lying. And that, I think this goes part of what you were saying before too. Like juries have a hard time with this because, if someone's lying, sometimes, you can, and they're dissembling and they contradict themselves. Like juries can pick up on some of those things, and defense lawyers can exploit some of those things. But if someone truly believes something, juries just aren't that good at identifying when that's wrong. So those are the core four. I mean, there's other important protections. Not exposing a witness to the suspect more than once is a really important one, and that was a really big issue in Marvin's case. And the basic issue there is, you should only have one lineup procedure with that, where you show that a single suspect to the witness, because for a couple of reasons. One, if you do it 2 lineups and the same suspect is in each of them, well, now in that second one, they look familiar, right?
Right.
Because you've seen them. And it's hard for witnesses to sort of disentangle, like, that face is familiar. Is it familiar because I saw them do the crime? Or is it familiar because I was shown a lineup with their face? So you've sort of tainted the process.
And that was an issue that Jennifer Thompson talks about too. She first saw, I think, some kind of drawing. But anyway, at the beginning, she's like, well, that might look like him. And then I think she saw some kind of lineup, and it might be 6 or 7, something. She was kind of waffling between 2. With the confidence statement, you would know how confident or not she was, or the witness was, at each stage of the identification. And as you said, there were so many identification procedures with her that she kept seeing only one person multiple times in all of this, and she got more confident. And I also think there's obviously if the state is going to the effort of charging somebody and having a trial, then the witnesses go, oh, well, they must have the person. I must be right. And so it's totally understandable why they get up there, they see one person sitting next to defense counsel, and they feel really good and confident about their identification, which does not relate to the accuracy.
Yeah, absolutely.
So the county attorney's office here has adopted a policy about eyewitness identification, even though the state actually has a statute on it. Can you talk about why or what the need was for a specific policy in our office?
Sure. Yeah. We do have a statute that covers some really important sort of bare minimum requirements for police, but there's a lot more that we can think about and do beyond that. So our policy, which we adopted last year, it does a few things. It gets quite in the weeds, but generally speaking, it tells our prosecutors that if we have a case that's really built around an eyewitness identification, where that is central to the case, we should be exercising a lot of caution, because we know there's a huge risk of error there. So if this ID is kind of at the center of the case and we don't have a case without it, we want to make sure that's a really good, really reliable identification. Second, we want our prosecutors to be aware of and familiar with sort of the basic learnings on a wide range of issues that bear upon assessing the reliability of these identifications. We don't want them just thinking, can I get this in under the legal standard? Because that standard's not that high. We want to think about, is this actually evidence that we believe is reliable? Which is a question, we should be asking about all kinds of evidence, right? But, the nice thing is with this type of evidence, we have a lot of really specific research that we can lean on to help inform those decisions. And then the last part is making sure we're agreeing to the use of experts where that's appropriate, because there are so many issues that lay jurors just don't necessarily understand, and that can really help promote a fair process.
And it's been pretty common for prosecutors, I would say, across the country to just object to defense's efforts to get an expert to testify.
Yeah, that's sort of the traditional approach, and we've, moved away from that to try and be thoughtful about it. Is this a case where that would add value?
And you would agree that, certainly we have a statute. Defense can make a motion to suppress a statement. Those can be granted, but it can also be hard to get one of those granted. And it's also a big difference between getting that granted and having your case be dismissed than it is to have it never charged in the first place. There are a lot of consequences to just having a case charged. And so we want to make sure that we get it right in the first place.
Absolutely.
So let's circle back. We know that Marvin is seeking compensation. Can you describe a little bit about that process?
Sure. So in Minnesota, like most states, but not all, we do have a mechanism for statutory compensation for people who have been wrongfully convicted. Now, it's a fairly narrow gate. I mean, it's people who have been exonerated in kind of the fullest sense. They've had they've had their conviction reversed in full, no further charges, or else they're acquitted of any further charges.
Does the prosecutor have to agree to that?
The
exoneration.
They don't have to. So there's kind of two paths. So if you meet that like initial kind of basic definition of exoneration, then you can file a petition under the statute. The county attorney's office that was responsible for the case can at that point agree, like, yes, under the law, this person is eligible. We would never have brought this case if we knew what we know today. And that's conclusive. Like, there's no hearing, there's no judge.
And we
decision.
did that in Marvin's case.
Yeah, and this office did that in his case. If you don't do that, then you have an evidentiary hearing, which is basically a mini trial where the person has to prove their innocence, which can be hard depending on the nature of the case, because then the burden is on that person to affirmatively prove their innocence. But that's how it goes if the state doesn't agree. And then from there, there's a panel of judges or a panel of lawyers or judges that's appointed by the state Supreme Court that decides the amount that they get. In Minnesota, it's a baseline of $100,000 a year for a year of wrongful incarceration, plus individualized damages, which can drive that number up quite a bit depending on the specific medical, mental health, financial damages that someone might have suffered. And then the last step is the legislature has to approve it, which is something that's a little bit different about our process. That's actually not typical in most states, but that is how our law works. So, and Marvin's claim is that less, as we sit here today, in the final stages of the legislative approval.
And the amount there is $4.5 million.
Yeah, which would be the highest amount that's been awarded under this statute, in part because he was in for almost 20 years, which is the longest of any of these cases so far.
So we're going to talk to Claire Deagle about what the office learned there and what we did. But I think we have to say no amount of money gives somebody back 20 years of their life. And so it's really important for offices to think about how these wrongful convictions happen and what they can do about it.
Yeah, absolutely. I mean, the best thing we can do is trying to prevent them on the
Yes.
front end, which is, what we hope to do going forward.
Thanks, Andrew.
Thank you.
You just heard from Andrew Markport, who now heads our Conviction Integrity Unit. We're now going to hear from Claire Deagle, who is the director of our Professional Standards Division. Among other things, she supervises our training division, and she's a partner who works frequently with Andrew in the CIU. I'm here with Claire Deagle. Claire, you were integral in helping us create the Conviction Integrity Unit. How did you do that? What did you look at? How did you arrive at where we are right now?
Sure. So you and I have a lot of discussions about the importance of having a conviction integrity unit that lived within the prosecutor's office. Inside the prosecutor's office, we have access to all the case files. We have access to the people who may have been involved. And it's really important that as prosecutors and ministers of justice, we're always looking back to ensure that we can stand behind our convictions. So I started doing a lot of research on conviction integrity units that lived within prosecutors' offices. And it became very clear to me that we really needed a subject matter expert, someone who has a lot of experience doing this work, because it's not only issue spotting in case files, it's really having a deep understanding of some of the issues that we see on post-conviction, like eyewitness identification. So I started talking to experts across the country and within the state to kind of learn who we needed to have on the team. And it was clear we needed to have someone in a managerial position. We need attorneys to review cases. We needed an investigator and then, of course, support staff. So with your blessing, we went to the county board and got budget allotments for those people. And then we were very fortunate to be able to hire Andrew Marquardt for that lead role.
So Andrew and I talked a little bit about how important it is to try to learn from wrongful convictions and try to make sure that they don't happen again. And we certainly learned from what happened in Marvin's case, as well as some other cases that we've seen. So, and I mentioned you were also in charge of training. You oversee training. So what did we do with the takeaways from Marvin's case and others?
Absolutely. Well, knowing that the primary issue in Marvin's case was eyewitness identification, we sought out an expert to conduct some training for our office. We brought in Dr. Nancy Sablai to do a 2-part training series for our attorneys on eyewitness identification. So first she came in and she talked about the basics. She talked about the science, and she also talked about a law that we do have in Minnesota about eyewitness identification. So just really the basics. Our attorneys had baseline of knowledge.
And one of the reasons that's important is Andrew and I were talking about the science behind eyewitness identification is not necessarily intuitive. That's true for jurors. It's also true for lawyers. So, for instance, it may be that our prosecutors weren't aware of some of the science as well.
Absolutely. And if you don't have awareness of the science, then you're really not able to gauge the validity of an identification. So that was really, really important. And we're so fortunate to have her do that for us. And then the second part of the training was a deeper dive, really about strategies that we need to be using when we're evaluating eyewitness identifications. What are the red flags that we need to be looking for? What are the issues that we need to know about that could lead to a wrongful conviction? And then also, how do we move forward? What should we do as an office to make sure that this doesn't happen again? And after those trainings, it was very clear. And Andrew had also been pushing, of course, with you leading the charge, for a policy on eyewitness identification in this office. So that was our third step. And Andrew and Dr. Sablai put together a policy, a very comprehensive policy on eyewitness identification that our attorneys need to follow, and that provides them guidance on how to use that sort of evidence in our cases.
And to be clear, there is often a lot of other evidence. So when we look at the policy, it could be that the eyewitness identification was problematic, but there is other evidence that would lead us to be pretty confident in charging the case.
Absolutely.
You mentioned Dr. Sablai and Andrew came up with this policy. Did you look to other jurisdictions to try to find something similar, or what happened, or how did you come up with this policy?
Absolutely. So that's always the first step, is reaching out to other prosecutors' offices around the country. And we're very fortunate to have contacts all over the U.S. Unfortunately, here, we didn't identify a policy that was really sufficient to address the issues. So Andrew and Dr. Sablai, along with our criminal managers, put together this great policy, and we hope that other county attorneys' offices and prosecutors' offices will adopt a similar policy to make sure that what happened to Marvin doesn't happen to other people.
We are going to be having a separate episode on conviction integrity. But when people think about it, they're thinking of the sole purpose of finding innocent people. And I think this is a good example of learning from that as well, to hopefully prevent something like this from happening. Because as I talked to Andrew about, $4.5 million sounds like a lot of money. It's also not a lot of money when you've taken almost 20 years from someone's life. So our hope here is that we will prevent a wrongful conviction involving eyewitness identification.
Yes, definitely.
Thanks, Claire.
Thank you.
So you've heard from Andrew Marquardt and Claire Deagle about what the office learned from the Marvin Haynes case and what steps we took to make sure that something like this would never happen again, at least as to eyewitness identification. If you enjoyed this podcast, please give us a high rating and please join us for our next episode. Thank you.